Hey Marie, I'm here. I'm just gonna run outside to walk my dog, okay?
Sure.
I'll be right back.
Yeah. Oops. Evening, Laurel. It's Mark.
You know, I think some of this process.
Laura, can you hear me?
Yes, I can hear you. I muted myself because Max was howling.
Laura, you're gonna have to share your screen.
Okay. Let's see.
You gotta learn how not to share before you're ready. I mean, I don't care. I'm just saying.
I hear you. I thought you were sharing your screen.
No, I'm at fees, and I forgot my thumb drive.
All right, hold on. I gotta find Ms. Howard's email address.
All right.
People pay at the last minute and you make me crazy.
It's all right. That's what Brian used to say when everybody was getting ready for Gene's class. It's like everybody pays at like the last 5 minutes. Wow.
Not guilty.
This is my day. Copy and pasted freaking emails all day. Oh
Not
my
a bad day.
God. Killing me. All right, let's see here.
Well, that's good.
Copy. Oops. I'll do that later. Hi, Anil. Where are you at?
I'm in Colorado.
Oh, okay.
Oh, is my, oh, hold on, let me mute this.
I'll mute y'all in a second. I'm just waiting for, oh, you're laughing. That's fun. All right. Let's see here. Okay.
You're recording, right?
I am.
Yeah.
Ooh. I'm gonna mute everybody.
Being Jillian with a plunger. No, it's where I hang out. She just won't get out.
Excuse me? Donald. I think that's the last person.
All right. Laura, you ready to get going?
Yeah.
All right. Open up the indemnity bond first. That's the insurance. We'll go over it. Indemnity bond. Right there.
That's a cover letter.
Or that.
There you go.
Yeah.
That's mine.
Go into the folders and pull them up.
All right.
And then we'll fill it out. Go down so everybody can see how to fill it out. There you go.
All right.
Okay. All right, I'll see you in a little bit. All right, guys, this is a private registered indemnity bond. It's going to be for $100 billion. We're going to do a BC bond order for $100 billion, and we're going to do an international bill of exchange, non-negotiable, for $100 billion. What these three things do is that one, the BC bond order is charging up your account, and you'll see in the cover letter when you're going to liquidate your estate, this is what you're liquidating: all these bonds, your birth certificate, etc., your Social Security account. This is your insurance. So if you need health insurance or car insurance, these bonds can be lodged with the Secretary of State and then referenced for insurance. So if you get into an accident, this bond number that I'm going to show you how to create along with a registered mail number and your UCC1. It also, from last class, we went over the legal notice and demand. These bonds are registered at the bottom of those. So it would be, QSIPs are 9, so keep everything to 9. So it would be 0000001, and then your initials. All right, I'll start at the top. All right, so where they're getting the bond number from, it's U.S. indemnity bond. So mine was PJP indemnity bond 0001, 4 zeros and a 1. Then it goes into, so mine would be registered New York UCC file number, and then you put your UCC number, and you'll get your maybe I'll teach you guys how to do the UCCs as one class with the UCC3s and the addendums and the assignments and the registration of notes and collateral, and I think that would be a class on its own next class, and then Sean can show you guys how to do the address change. I think that would be cool. All right. Cool. All right, then it says, paid to the order of the United States Department of Treasury. This is going to be, I made two, one for Raul Maldonado, and at the time when I made these, it was for Jacob Liu. Now it's Mr. Steve Mnuchin. So I would make two up referencing the same registered mail number. Yeah, keep it all one registered mail number. You don't, all right, let me think this out. Yeah, use one registered mail number, and then just you have to address Mnuchin on the one. The main guy, the main pack that you send it to is the Puerto Rican, Raul Maldonado. He gets the main pack. Okay, so. Now the principal will be Laurel. Go into the principal and type in last name, first name, middle. So they can see it. Now, when you see the registered mail, what the registered mail does is this: how you take private funds and make them public. This is what registered mail does. And once registered, they become a security, and that's governed by UCC Article 8. And then your private offset account number is your Social Security account without dashes. And on all my paperwork, I've been putting the exemption bond number, which is the letter and the number on the back of the social. I'm not using the routing number. I'm just using the letter and the number, because that's a bond number itself. And that's the private side because it's in red. On the front side of your Social Security card, that's public. On the back side, it's private. It's all accounting. Awesome. Okay, now this is where you're going to need 2 sureties. You're going to need 2 other creditors that have already sent their bonds in, that have cured. It takes 90 days for bonds to cure. You'll have their Social Security number without dashes, their bond exemption number, and then their registered mail number that they use to register their indemnity bond. And the same goes for, and then you see how the bond number, and it has the initials, and so mine would be PJP Indemnity Bond 0001. And same goes for surety number 2. Same process. And I changed this to 100 billion. I keep everything at 100 billion. I've seen other people do it for 100 trillion. People get out of hand sometimes, but there is a threshold. I think it's 100 million when you sit down, when you think that's what they go for liquidation terms. When you liquidate your estate, because what this paperwork is doing is the Sestacade Trust was created in 1666 for the benefit of man. And in 1933, our strawmans came along, and they put our strawman estate inside the Sestacade. So these forms, including our security agreement, all the forms we've done, plus this, is reclaiming that estate, taking it out of the Sestacade Trust. We're charging the account up. You'll see with the BC bond order. Then we are insuring ourselves. It's all insurance anyway. Surety bonds, indemnity, everything's insurance at the end of the day. So, all right. Polinsky, Peter Joseph, principal, and then you have your 2 sureties being creditor, sui juris. He's never pro se. We are not pro se litigants. We are always sui juris. Always. And beneficiaries, no matter what. Status of sound mind, standing in honor with full knowledge and full disclosure with honorable intent. Herein hold, bind, and obligate ourselves individually and cooperatively, jointly and severally as voluntary sureties for herein and account holders and accounts. And then, all right, keep going down. Keep going down. All right, so, okay, hold on. All right, so at the bottom, and I'm in the process of scanning, I'm unbinding my trust pack. Because once you get everything done, you have to bind this. It's got to be binded or bound, uniform bonding code, bonded. And you can go to FedEx, it's like $10 and they bond it for you. It's nothing crazy. So anyways, so you'll see my finished product. So down where it says surety 1, surety number 2, this is where you're going to put a red thumbprint and then sign it in red or sign it in gold. I've been signing everything in red. The only time I use gold is when I'm signing over the postage stamp.
Gold
So again,
for what? What's gold for?
gold means royalty. That's what kings sign with. Or purple. Purple is royalty as well. But gold on so gold on the periodic table is AU. That's your autograph. You're the author, the authority.
So So you don't use gold here for what reason? I'm trying to figure. You use
No,
red here
I
because
use. All right. So when we get, you'll see when we get down, because you're gonna need stamps at the last page. This is where I put the stamp and I sign in gold. I only sign gold over the stamps. Makes you the postmaster, and that's how kings sign. But like Gene says in the IRS manual, they say to sign in red.
okay.
So surety 1, surety 2, you put your thumbprint, you sign it, sign your name, last name, first name, middle, always your private. Same thing for the principal. Down here, you reference your indemnity bond number and then your registered mail number.
When you say down here, okay, at the bottom. Okay.
Yeah,
I
the
didn't
footnote.
figure-
Your
I didn't
footnote.
figure-
Sorry. All right, go down, Laura, please. And then it's another bond order. This is where you have to go in and change the Secretary of State's name, or the Treasurer, excuse me. Put it on Raul Maldonado. He's the governor of the IMF. So again, with foreclosures or anything to do with court or mortgages, the IMF is the real party of interest. So any other attorney coming in or bank coming in trying to collect funds, Federal Rules of Civil Procedure Rule 12b2, lack of subject matter jurisdiction, which means the attorneys never gave factual testimony on record. So everything that they say is hearsay because they're not the real party of interest. And then you just remove that, go into Federal District Court. They have original jurisdiction, Title 28 USC, Section 1333. And all the attorneys, the judges, they all have insurance. They all have surety bonds. That's why when you put your affidavit into the state insurance commissioner, this is how you put an insurance claim. And you attach the charges to the affidavit, which makes that a true bill. 90 days after that, after 90 days, the affidavit becomes a accounts receivable. Now, if you get that and go get your certificate, because you default them after 90, get your certificate of default, open up a brokerage account, get a security broker, and then they'll do a dividend payout. And then, like I said before, the accounting for dummies, it has 9 books and it shows you how to calculate the dividends. So you know you're not getting ripped off. So you know what you're doing, and you can watch over your security broker that you hire. Anybody that you hire, you should know their job better than them, no matter what. You're basically hiring them for like a bridge or like a cross or like a pass through, really. So, all right. Keep going down, Laura. Same thing on the bottom for the sureties. Every page gets a thumbprint. And on the back of everyone, on the back bottom right corner, I always put a 2-cent stamp, thumbprint it, and sign diagonally through it. And you guys will be getting, next class, you'll have pictures of all this stuff. So keep going down. All right, so this is where it gets fancy. So right on the top where it has the thumbprints, you put your thumbprints in there, surety 1, surety 2, and your principal, and sign through it. But in the middle here, where Laura was showing you, this is where I put the stamps. I put $1 stamps, 1, 2, and 3. Sign over them in gold. The thumbprint will be half on the stamp, half off of it. And then the signatures, last name, first name, middle on everything.
Do you have any thoughts on using international stamps since they don't have a GST on them?
I have Red Fox stamps. I have the ones from the Swiss, and I haven't used international stamps. I've only been using the $1 ones.
Yeah, the international stamps don't have a tax associated with it.
Really?
Yeah.
Well, then I'm gonna start using those. Those are at the post office, or you have to order them specially?
No, they have them there. They have the chrysanthemum, the moon stamps. They're like $1.15 in value.
Ah, gotcha. Now I know what you're talking about.
Okay.
All right.
It's just an idea. I heard.
Yeah, no, I'll use that.
In Australia. They talk about it in Australia. So.
Awesome. Okay. So then down here, you're also going to need, on top of the 2 sureties, you're going to need 2 witnesses. And so you're going to print the name, and then they'll sign it, last name, first name, middle, and then their addresses. They can put the thumbprint to their name as well. And then that's pretty much it for your indemnity bond. Like I said, this is your insurance. You can lodge this with the Secretary of State. You can, so if you get into like a car accident and they need your insurance number, it'll be the registered mail number. That's your account number. And then the other account number associated with it will be your social security number without dashes, and then your bond exemption number. So that's 3 numbers that they can hit either way. So that's your insurance. If you need something like medical insurance, you can lodge. I haven't done anything with medical insurance. I've discharged medical bills, but I haven't lodged anything for insurance wise. But you should be able just to reference this for insurance. Like if you go there and you get a bill, you put your indemnity bond. I'll show it to you after. All right. So anyways, that's your insurance, and pick up the bill of exchange now. Secure creditor 1. Redemption 4-5. And then, 7 birth certificate chargeback, bill of exchange. It's up. Yeah, right there. There you go. Okay. Now this is your non-negotiable bill of exchange. Up top, it's going to be, all right, so I have all my clients, I have them get 3 different registered mail numbers. The most important registered mail order will be your VC bond order. That's the one that's going to go on the outside of your entire pack to Raul Maldonado. That will be the most important registered mail number. If you can't get the other 2, Laurel knows how to put the complaint into the post office and get a whole roll of registered mail numbers. They've been really difficult to get registered mail numbers. They want you to do your paperwork. Come there, grab one registered mail number, write all over your paperwork. It's annoying. So
I tell them I'm an executor of an estate, or I tell them I'm a notary public, and I do a lot of register mailing, and they give me
they try to fight it. It's funny. Okay. They try to fight it. But yeah, I say that too, because when you told me to go get the firm mailing book, PS Form 3877, that's what I said. I was like, I'm the executor of this estate. I got estate mailings. They're like, okay, hold on. They had to blow the dust off the book. They're like, nobody asked for these. And I was like, that's what they told me. Good experience. The post office is always good to me, where I'm from. It's like what I tell everybody. As soon as I leave my city, I get the worst hassles in the world. They know I'm coming, that's why. But everybody in my city takes care of me. I love my city, man. Okay, so that top is going to be, so get 3 registered mail numbers. If you can't, then just use the 1 registered mail number for your whole pack. Just stay consistent if you can't get the 3. Then change it up top to Raul Maldonado, get the address, date it. Cool. Then, okay, so enclosed are documents from my examination of my commercial agreements, which I have accepted for value, all related endorsements front and back to include those words in accord with UCC Article 3-419. So that's Article 3-419 is for all contracts. That's where you accept everything. Accepting the charge is accepting the Christ. That's why at the end of that, when they hung Jesus or nailed Jesus to the cross, and the one guy denied Jesus and went to hell or whatever, and the other guy accepted him, made it to heaven. Accepting, that's your heavenly realm. That's how you enter the gates of heaven. You're not arguing or slaving away for stuff that's already prepaid. You know what I mean? You're in heaven's land now. Everything is prepaid. The total amount of the non-negotiable chargeback enclosed is 100 million. Please charge back deposit into my UCC contract trust account at 100 million, and charge my account for the fees necessary for securing and registration for the priority exchange for the tax exemption to discharge the public liability of my personal possessions, and command memory of the account, your social security number, to charge the same to the debtor's order or your order. The posted registered mail number and assets funds is part of my tax estimate and is directed for use for Republic, Article 4, Section 4 of the United States Constitution. In accord with public policy, I put 7310 for the public policy and House Joint Resolution 192. And Title 31, USC 3123. Yeah, so comma, Title 31, USC 3123. No dash. Awesome. Mr. Maldonado, as secretary in charge, and your deputy in charge, or take my banker's acceptance. This is Article 7, receipt in exchange for the tax exemption priority. This non-negotiable bill of exchange / trade acceptance is in accord with HJR 192, June 5th, 1933, and is presented for the receiver to the federal window for settlement, electronic funds transfer within the 3-day truth in lending time for settlement of retail agreements. With this posted transaction, the chargeback charges documented by enclosed forms are for use by the Republic and is complete. If you need more information or assistance with charging my UCC contract trust account, you may write me sincerely. And then I always put, again, at the end of all of my letters, this letter is written, or this is all in good faith. If it's not a letter, then I say this is created in good faith. And then sign your name, last name, first name, middle. And then at the bottom of all of my bonds, you can use your international one. I put a $1 one on my bonds and a 2 cent on the back, bottom right. But for this one, I'd put the dollar on there, thumbprint it, sign it through gold, and date it.
Yeah. Should that be HGR 192 or public law 7310?
They do public policy. They don't do public law.
Public policy. I apologize.
That's fine. You're good.
Because I'd heard.
It's okay. So the reason I mentioned public policy 7310 is because HJR 192 was not amended, but they changed it. So now they go by public policy 7310. But I always mention both of them because HJ 192 still has the gold clause in the executive order. The only thing that they changed was some businesses can register to accept gold now. That's what was amended in our HJR 192. But the corporation is still bankrupt. Don't matter. All the estates is bankrupt. Everything's insolvent. All right, this is my favorite one. Go to the BC bond order. That's going to be in, you go down. Go down.
Who did you say that you would send that letter to, real quick?
This all goes to Raul Maldonado. You're going to notify the Secretary of State, Department of Transportation. You're going to Secretary of Department of Agriculture, Secretary of State, Steve Mnuchin, the IRS Commissioner.
This is the letter that you're sending all of them.
Yeah, this is part of the Treasury package.
Okay.
Non-negotiable
Gotcha.
bill of exchange. As part of charging up the account. All right, go to new BC bond files. Yeah. BC registered bond for set off. Oh, no, the word one. The word one. It's all right. Hold on. Let that load. Oh, no, this is the one. This is the one right here. Yeah.
Can we go to view single page in the menu system? Home, insert page layout, references, mailings, review, view. Instead of two side by side. Would that bother you?
You do what you want.
I can't.
Oh,
Okay.
No,
Well-
I just need to figure out how to do it.
Go to view.
Go to review. Yeah.
No, not review. View Click.
View.
and do page width.
One page.
Go to page width. One page. Now you can go to page width so you can read it. There you go.
My man.
Thank you.
Thanks.
Yeah, thank you.
My eyes are like screaming.
All right, so up top left is gonna be last. I don't do the colons anymore or writing the name as fact. I just keep it private. It should be last name, comma, first name, comma, middle. I use my home address. You can use your PO box. It doesn't matter. And then to the right, it'll be the date that you created it. And then your bond number, you see, becomes the registered mail number. And then you have to list the registered mail number below it. Then it'll be Mr. Raul Maldonado, Secretary of the Treasury, Puerto Rico, P.O. Box 21210 or something like that. In fact, I can't remember it all.
We're going down to Puerto Rico because of the trust 62 and 73.
Right. I mean, well, the reason why we go to Puerto Rico is also because it makes it international.
All right.
And then, all right, private registered bond for set off, non-negotiable. Value of the bond, 100 billion. Now, this is where you need your certificate of live birth. If you don't have one, like I'm pretty sure Texas only has like a birth certificate. Just list your BC number. If you have both, list both. Then accepted for value and exempt from levy, deposited to the U.S. Treasury and charged. Then it goes to your estate name, put your social there, and then like I've been doing lately, it's not on mine, but you can add the bond exemption number on the back of your social. And then again, enclose the undersigned Polinsky Peter Joseph herewith, accepts for value the enclosed bond, certificate of live birth number, and all endorsements front and back, being the only legitimate acceptor of said bond, being the only party to have put any value into said bond, being the contributing beneficiary of the same. This is in accordance with the uniform, they got public law on here, wow. And the House Joint Resolution 192 of 5th June 1933, UCC 1-104, and Public Law 7310. So I guess, never mind, I've been using public law. I always get them mixed up. So on the bill of exchange, do public law, don't do public policy. My fault. Then your bond order. Please deposit this bond to account bearing the U.S. Post Office registered mail number, for future identification without dashes, purposes and to be used as a set-off account. For future identification purposes and to be used as a set-off account against any bills, taxes, or claims, and the like
Here it is.
against. Upper, lowercase, so that'd be your last name, first name, middle, and then it's your social security number without dashes. Or any bills, taxes, or claims, and the like, secured party. See enclosed UCC-1 financing statement. Said claims to have been accepted and endorsed by last name, first name, middle. I'll go down. Please adjust any bills, taxes, or claims and the like against last name, first name, middle. See your certificate of live birth or the principal, lowercase, last name, first name, middle. And then as the above location, Raul Maldonado, the Secretary of the Treasury. The United States Department, Post Office, international mail receipt to dishonor this bond by returning this bond to the principal. So once you send this stuff out, if they don't send it back within 30 days, it's accepted. There's no argument. You're in accord. You guys are in agreement. And now you're just going to wait for your bond secure to get your green card back. And once your green card back, that means your account is set up. Once your account is set up, then you can start getting your 82 numbers, your FINS numbers, your cage codes, your investment accounts, your foreign trust numbers, foreign estate numbers. You get your death certificate. That's when you can liquidate your estate. This is when you can default judges, corporations, trespassers, and get dividend payouts from the default. All right, this bond shall be ledgered as an asset as best suits the needs of the United States Department of the Treasury. This bond expires at the moment you die. And then simply at the end, void where prohibited by law. So if this in any way document is unlawful, send it back. Don't keep moving it forward so you can try and charge me. If I say it's unlawful and you know it's unlawful, don't move it forward, homie. And again, principals, last name, first name, middle, social security number without dashes. I've been adding the bond exemption number on the back of the social. Whenever I see my social, I put the social in blue, and then I put the bond exemption number in red. And then your sureties, you're going to need this is where your sureties come in, people that are other secured parties, and I think you need 2 witnesses. Go down there. Yep. There's your 2 witnesses. Sign them. Last name, first name, middle. Sign everything in red. Thumbprint it. All right. Now we'll go to the cover letter. I should have did the cover letter with the shade.
Real quick on this thing. Up at the top where it said BC number, is that the number at the top right of the birth certificate or the one on the back?
There should be one. Do you have one that's in red? One of the numbers in red.
It's stamped on the back.
Is it red?
I think it's black.
All right, so then I would go to the front page and use that one.
Okay, thanks.
So you want the master bond number, not the issue number, because there's 2 numbers usually when they, with the certificate area,
Right.
you get the master bond number.
I think the top right is the issue number.
And then for
Does it
each
say
type of-
issue number by it?
No.
I believe that's what mine says. It's from Georgia.
I'd have to see it. Just send me a picture of it. I'll tell you.
Okay.
It's weird. BJ used to, when I get birth certificates, each one would have its own issue number down by the signature in the right corner. And then I did the special deposit it back to the issuer, and now it comes out the same number every time. No longer changes. Something changed in the back.
You're on it. You're on it. You are on it. All right, yeah, Laura, pull up the cover letter. Not in there. Go down.
Quick question: where are we looking, or where could we look to find people for surety numbers? Are we just going to friends, or is there?
Well, I'm a
company or
I'm a surety, and I could see, and Laurel could be one, and I got a couple old boys in Missouri that could be sureties. I got my boy in Brooklyn that could be a surety. That's something that I'm gonna have to put together for everybody. I got plenty of people for it.
All right.
Yeah. What's that cover letter? What's this? No, that's not it. What's that say? All right, back out of that.
I'll open mine. Hold on.
All right, cool. Thank you. Rah. Okay, notice by last name, first name, middle, care of, the date she made it to Raul. There's your P.O. box. There's the address. Here's your registered mail number. This is your BC bond order registered mail number. So when I ask for the registered mail number, this is the BC bond order. All right, go down. In the matter of your certificate of live birth, you put the number there, accepted for value, and exempt from levy. Duly notice, Raul, Secretary of Treasury, Department of Treasury, with my acceptance for value of certificate of live birth number, and to the issuance of the private registered bond for set off, non-negotiable numbered. This is where you put your bill of exchange. Registered mail number.
Satisfy the situation so I can hold down the fucking fort, and I have a window, and my windows.
Excuse me?
Hello.
That was odd.
All right, so enclosed are the following instruments: private registered bond for set off, non-negotiable, BC bond order, in the amount of 100 billion. See certificate of live birth number, duly endorsed as follows. Then it says non-negotiable chargeback order, priority exempt from levy, prepaid common stock. Office holder, Secretary of the Treasury. I accept for value all related endorsements, presentments, and fees in accordance with UCC Article 3-419, HJR 192, Public Law 7310, and Senate Document 43rd, 73rd, Congress. Command the memory count. It's where you put your estate name with your social. Charge my private prepaid Treasury account, social without dashes. Command the memory of, all cap name, discharge all presentments, and zero the balances. IRS form, see this way we're going to add the 1040V. You're just going to have to accept, you don't have to fill it out, you just do an acceptance on it. And the same thing. Keep going down, that's it. That's your cover letter. There's your signature block. There should be a jurat on there. So it could be notarized. You don't gotta put it on now, don't worry about it. All right. All right, so those are the bonds that go with your treasury pack. That's what charges up your account, charges your estate. Pull up the BC affidavit. I forgot to go over that. So after you authenticate, did we go over the W.A. Ben, Laura?
Yes, we did.
All right, good.
Was that in the last class?
Yes.
Okay. I still need to order that from you.
What do you need, PJ?
Pull up, we'll do 56s now. Yeah, do the Timothy one. All right, this is an outdate. Just pull up on Google IRS Form 56. We'll just fill it out right now. Type in IRS Form 56 PDF. There you go. Cool. Can you fill it out or no? No, right?
Nope.
Open with a different viewer, upper right-hand corner next to the X. It'll open in Adobe. Don't you have Adobe Reader in that pull down? See the open with radio button?
Right there. Other.
Adobe.
There you go.
There you go.
Hey, Pito.
So,
Yeah. So today is July 18th, 2018. Okay.
In the Roman calendar, it is, yeah.
Yeah, okay. Yeah, we ain't gonna argue that point. 4 years ago today, I was locked up. I was in jail for seatbelt violation, fleeing and eluding. And so I attempted to do a Form 56 on 2 judges and the DA. My wife brought my paperwork to the jail, and basically, I was rearrested while I was in jail for 6 felonies. 3 for forgery and 3 for identity theft. So I called the public defender today and I said, hey, today's 4 years statute limitations. And they told me the DA has to dismiss the case.
Good. There you go.
Yeah, but, you know, these people don't like me, man.
Good.
And I need this shit to go away. You know what I'm saying? So,
Affidavit of truth in the state commissioner office. For
okay. Okay. So the point of it was,
put the charges on the affidavit and put the sum and send it to him. That's a true bill.
okay. The reason why I got arrested because I messed around and I signed where it says signature. And right now you can't see it, but I think it's on page 2 where it says signature.
Right.
And I signed authorized representative, but I didn't sign for my name. So they assumed I was signing for the judge. Well, they're dumb as a bag of rocks.
Right.
But not only that, they ended up, I went outside my house Saturday, and they have for sale signs up because they said that the tax commissioner owns my property. So what I need to do with that?
All right, after class, send you. I gotta see the correspondences in your paperwork.
Okay.
Send it to Laurel, and then I'll call you tomorrow. We'll set up a date. I gotta call Mr. Phillips too if he's on there. Alfred Phillips. I gotta call him. I gotta call Miss Rice, and then.
Yeah, because he was supposed to call me this week.
Yeah, I've been busy. I just got back from Missouri. I wasn't talking to anybody.
Okay.
I'll call you tomorrow. I'm back home.
Okay.
Get with Laurel. I'm usually free around 3 or 4 p.m. on Eastern Standard Time. I'm usually free around then.
All right. I'm heading up that way.
Yeah, you told me when you in Philly. Let me know. I'll come down there and fuck with you.
Yeah, definitely, man. You know, I'll be up there either 28th, 29th to August the 6th.
All right. I'll come down and see you.
All right.
All right. All right. So this is IRS Form 56. Now, this is your fiduciary relationship. Now, what relationship do they have to you? They are public trustees. All the way down to the garbage men, they're public trustees. IRS agents, trustees. Judges, public trustees. I don't care if they sit on the Supreme Court bench, you're a public trustee. So the first one that we're going to fill out, this one will be, I'm going to show you how to fill it out too. One for them appointing them as the trustee, and then we'll do the second one appointing yourself as the executor. And then I'll show you, and then I'll explain what you do with your 56 with that. And this is important for the boys in Missouri, because I forgot to tell you this. So I'm going to tell it to you after I finish this. All right, so name of person. So this is where you'll put Raul Maldonado, all cap, Raul Maldonado. Oh, no. Yeah, go ahead. Put, no, my all cap name. Yep. And then just put 1 through 9. No dashes. Don't put the decedent's social security number in there. Just leave your identifying number. That they consider the number without your dashes as the auto tryst number.
When would you use the decedent social?
On the 82 when you're filling out your estate.
Okay.
Getting your 82, 83 number. Well, I'll have a class on it. Take us 5 minutes to do.
Okay.
All right, so put PO Box 614. You can use your care of address, but for now, when you do your address change, it doesn't matter. Everything's gonna come to the PO Box, your suite. So Marcy. New York 13403. All right, now this is fiduciary's name. Now this is going to be Raul Maldonado. And then P.O. Box, yada, yada, bada, bada, bada. Yep, okay, good. All right, go down. Okay, so this is where I check off F. This is where I do other. Now it's not gonna see this, all this clear space, this like a box up here for A through E and all this clear space up here. All right, so I start where after box, go put it after C, authority for fiduciary relationship, check equitable box. This is where I start my writing. I say, this appointment. Laurel, can you open up a Word document and then I'm going to say it and then you can just type it so they can see it. All right, this appointment is for the Peter Joseph Polinsky estate, appointing Raul Maldonado as fiduciary trustee and this is in accordance with the 1951 Power of Appointment Act, codified in Title 26, United States Code, USC 2038 and 2514. So that's the verbiage that I use for the appointment once I hit pull up to 56. And that's where I put it there.
Would we use that same verbiage for pretty much any time we're using this with a public official? So if I'm doing this in court, can I give a 56 to the judge, the clerk, and the prosecuting attorney?
Yeah, you can, but you don't need to because you need to be in district court. That's where you want the appointments to come from, because whenever everybody gets run over in that municipal building bullshit.
I know. I just don't know how to get into district. District. I'm still trying to figure that out.
All right, so you have to do an order of removal. I'll do one tonight after I'm done with this.
Okay, cool.
All right. Okay, so that's an F. That's the other I described. So this appointment is for my estate. I'm appointing Raul Maldonado as fiduciary trustee, and then I list the laws of where the appointment comes from and where the power comes from. And I learned this from Gene.
That way they can't deny it.
Right. Types of taxes. So this is going to be gift and estate and generation skipping. It's not all at once, but it's all that we're going to be using this form for. I always check off all three. And then for number 4, I check off 706, 709, because that's your gift and estate tax and your generation skipping transfer tax. And then the 1041, because that's your trust and estate tax return. And then 5, I skip. Go down. All right, so for court, section A right here, total, this will click other. This is where you say all other fiduciaries are revoked. Pull up the Timothy Gunther one. I want to make sure I'm wording this right. I don't have mine in front of me, and I'm not going to steer you wrong. Yeah, let's see what that one says. Go down. Oh, they don't have nothing in there. All right. Screw it. Go down and finish it. All other fiduciaries are revoked. Only Polinsky Peter Joseph has the authority. Period.
Is it safe to just keep sticking with the last name, first name, middle name every time we use it, or do we need to go back and forth between how it was before and
the last name is your private name. That's how you come in private, and that's your estate name.
Okay, and if I'm using it in public, I can do first name dash middle name.
So if you're in public, then your trade name goes forward, right? You're a straw man. So that's when the Pharaoh told the Israelites to make brick without straw. That means to go do business without your business name.
Oh, gotcha.
See what I mean?
Yeah,
So
yeah.
if it's public, you just your trade name, your all cap name. But you'll see we'll be collapsing this, and we're going to create a new estate, a foreign grantors trust, an estate that we put inside the grantor trust. So we're replicating what they did, but instead of them granting it and having control over things, we're taking all our assets, putting it on our new estate and our new trust that we made, that we're the grantors of.
Okay, are we actually creating a whole new trust, or are we using? Okay.
A whole new one. A whole new
Okay.
one. It's not as hard as you think it is, I promise. I'm the only one in the world that it takes 5 phone calls to get 198 number. They hand these things out like Skittles. But I got mouthy with one of the IRS agents down in Missouri, so I went to call and they just laughed at me. And anyways, you have no idea what's going on in my life right now. But anyways, so there's C. Go down. Oh, see, all right, see, that was supposed to go in number 8, not 6. My bad. Yeah, so just do 8 and then copy and paste that. You can leave 6 blank. There. Now, when you get your 82 numbers and you get it notarized and stamped, time-stamped, not notarized, the IRS Form 56 will go along with your 82 printout. See, when you go for your 82 number on irs.gov, they'll ask if you want it mailed or printed out. I print mine out. I don't wait for it in the mail. And then I print out 4 copies. And you go get them time-stamped. Because that's showing you the executor of the estate. When you fill it out, you'll see. All right,
Do you have to go through probate for executor?
Yes, to get the decree as authorized. You want it to be authorized or personal representative. You want to be personal representative of the estate. And in your will, you bequest everything to the secured party. You'll see.
Okay.
So then part 3, you'll put the judge's name. You'll put the court clerk's name. These are all different ones. So for court purposes, you'll have like 4 or 5 different ones. You can put the state commissioner as fiduciary trustee. You know what I mean? They're all public trustees, and they have to protect your trust. If not, then they're in breach, and it's always for non-performance. Then it's always non-performance. So part 3, this is where you put your court address, the judge, court clerk, prosecutor, etc. Then go down and sign, last name, first name, middle. Now that's for your fiduciary trustee. Now I'm going to show you how to write this one out and make yourself the executor. So go up. All right, so the top is fine. And now when you go to fiduciary's name, this is where you put last name, first name, middle. Comma, yep, comma. And then, so for this one, so you're not confused, this is my care of address. 420. All right, cool.
So why did you use the all caps with your last name first? Wasn't that only for private?
In their system, everything's all capital, so don't get
okay.
It doesn't matter, you know what I mean? But when you're doing your paperwork, I keep everything all capital now, because that's how it is in their system. Everything's all capital. You can still do the uppercase, lowercase, but I just been keeping everything all caps.
Okay, so the uppercase, lowercase isn't as relevant as long as you're doing the last name.
Yeah, because your first your non-UCC filing, I have uppercase and lowercase on mine. But from here on out, I have all caps, everything.
Okay, you don't have to answer now, but I'm going to be curious about how to do the non-UCC, because I heard you can just pretty much check it when you do the regular UCC, but
yeah,
I haven't gotten any answers on that yet.
That's the non-UCC. You can either check the box non-UCC or don't check any of the boxes. It does the same thing.
Well, I submitted all my paperwork already, and I don't remember doing that. So
doesn't matter. You're fine.
Okay.
I don't have the box checked on my first one, and I have $100 million commercial lien on my shit.
Hey, PJ, can you hear me?
Yeah, what's up?
Question, I did not do a Form 56 like this in the past. Can I do one now?
Yes,
Okay, cool.
absolutely.
So everything that we've already filed, we can go in and change it or just,
Yeah,
Yes,
anytime.
the new
It's
ones.
your paperwork. You can do whatever you want to your paperwork.
okay. Because I did all
Nothing
mine
is
already,
ever
and
final.
I want to
If
make sure
everything
that I
was
do it.
finalized, my paperwork would be so trash, it wouldn't be fun. You know what I mean? Like, it would be so embarrassing.
Yeah,
You
okay.
it's your work, you know what I mean? And it's your paperwork. You can do whatever you want to it.
And what happens if I did not put stamps on my bonds?
That's just something I do.
Okay. I mean, they accepted them over a year ago, but
Then you're fine.
okay, cool.
You're fine. You're
Thank
100% fine. And then, Laurel, just put my zip code in brackets. Go ahead.
Okay, so what's the difference between what you're saying doing and what I did? Because if you're doing it for Maldonado, are you signing that or not?
Yeah, I'm signing it because I'm the one doing the appointment.
Right. Okay. So because I appointed the judge fiduciary, and when you go into, it's like the part where it says signature,
Uh-huh.
and it's a box underneath where the X is and stuff like that. I signed where it says signature, and over to the right,
Right.
my name as authorized representative.
Mm-hmm.
And they and one, I know they're dumb as a bag of rocks, but no, seriously, because they equated that to the fact that I was signing for the fucking judge. They charged me with forgery, and they charged me with identity theft.
Yeah, I'd have to see your tickets. See, it's okay. You don't just send a 56. Like, okay, so there's IRS Form 211, right? So that's a whistleblower form. Then you have to do 3949A. You have to call the criminal investigation department, mail all that stuff to them. And then you have to take everything into district court. That's where everything goes. Everything, you want the wins, you want your discharge, you want your set-offs. It's all in district federal court.
Right. Well, see,
So-
and that's the
So
thing.
when you're doing these 56s and you're not getting hurt and you're not getting any wins is because you don't have your counterclaim in federal court. Your bill of complaint. I'll go over it with you.
Okay, because basically,
I'll go over court. I'll go over court after this real quick. Just like a light, like go over it, and then I'll get into court next class. So with Sean, and Sean can do the address change. Show you how to get it back because you guys are presidents. And
well, see, I already have my change of addresses stuff done.
awesome, but not everybody else does.
Right. Okay.
But I'll go over court with you. I'll go over it briefly and how I handle court. And next class I'll probably show you some of my templates that I put in court.
Okay, and also, could you have Laurel post the nativity affidavit, please?
Yes.
Because I need that. Thank you.
You want the affidavit of ownership over the birth certificate, or you want the patent of nativity?
Patent of nativity.
Gotcha. That's fine. Yeah, I'll post it. She'll post
Thank
it.
you. Thank you.
You're welcome. You're welcome. All right. So now go pull up that Word document so we could change some of the verbiage up. All right, so this is appointment for the, put that all caps. Yeah, that's gotta be all caps, my bad. And then Polinsky Peter Joseph. Estate appointing, no. After estate appointing Raul, put Polinsky Peter Joseph. Take out Raul. And then take fiduciary, no, that's fine, as fiduciary executor. And beneficiary. And there you go. Now this will go when you get your 82 EIN. This will accompany that. Get them time stamped, and this will help you in court as well. All right. And then the rest stays the same for signing it, and then you don't have to fill out Section 3 for the court addresses. You leave all that blank. You wouldn't need it. But everything else stays the same. Gift and estate generation skipping, 1041, the 706, 709. That's all good.
So Peter, you don't appoint Stephen Mnuchin as fiduciary at all?
Yes, I was just going over the one. You could do Mnuchin. You're going to want to do the Secretary of State. You're going to want to do IRS Commissioner, Secretary, Department of Agriculture, and Department of Transportation.
So how many Form 56s are we going to need for this?
I think I did like 8. I'll put the list up of everybody that you contact. I'll put the contact list and everybody it's just a public notice. It's not like you have to record anything. The main people, the most important people is Raul Maldonado, the Secretary of State of the state that you live in, and your county clerk. And the most important one of all of them is the county. That's where all everything happens at the county level. Everything. It's cool to notify the Secretary of States and stuff. You have to. But the county is really the most important, where you make your public notices and you put the county, you go to the county deeds or the registrar and put your, affidavit of ownership over your birth certificates with your UCC1 security agreement, and that goes in the land records. I'll show you guys how to do all this stuff. All right. So what else? What we're gonna go over? 8832. I don't have mine with me. That's the classification of entity. No, do the from Tom or for Sim. So when I first got into Gene's class, this was one of the first documents that I learned how to file, and it helps your status with the IRS. So you're classifying your entity, your all cap name. So put my all cap name in there. And then that's just your social, no dashes. I didn't use my P.O. box. This is my home address. All right, that's fine. And then type of election, changing current. This is, you click A because this is your initial classification. Then skip lines 2A, 2B. All right, so so no for number 3. Name of owner, this is where your last name, first name, middle. Go down. 5A, none. EIN number, none. Up. All right, so then number 6, you're going to click F, a foreign eligible entity with a single owner electing to be disregarded as a separate entity. Number 7, if the eligible entity is created or organized in a foreign jurisdiction, provide the foreign country of the organization. It's America. It's not the United States Corporation. America is different. An own entity is itself. Election is to be effective beginning. So this is your date of birth, or your 18th birthday, I'm sorry. 7905. And then, so this will be your titles. last name, first name, middle, executor, president, treasurer, heir, beneficiary. Those are all good titles. Grantor, phone number, and then this is where you'll sign. Make sure your titles are in there. Go down. Okay, so this is, mine's a little different from this. I added on to it. But this entity is making this election is the estate created in the year of our Lord. And then you write out, Laura, look on yours. Is it the birthday or the 18?
Hold on, let me pull it up.
I'm pretty sure it's your birthday now that I'm looking at this.
I didn't do mine online. Let me look. Hold on, I've got my.
Yeah, I don't have mine in front of me.
Hold on.
But anyway, I'll keep reading. It's to mimic the private state, man/Trinity, / being also created in that same year. The body of we, the Trinity, which is referred to Polinsky, Peter, Joseph. Therefore, we, because, all right, so when he's talking about we, and they're talking about this Trinity, mind, body, and spirit. That's the Holy Trinity that they're talking about right now. You're the living person. You're not the dead, the corpse, the all cat. So we, the executor for his estate, is hereby seeking to update all records of the Internal Revenue Service and United States government of our competent exempt status, and to ensure of the correct classification of this, of this estate, created for our use and benefit. And we, the rightful heir, executor, and beneficiary. So what that all is doing is saying we're the executors, beneficiaries, and heirs of that all cap name. We, the Trinity, are responsible for all affairs. And down same, so you're going to sign here, you're going to sign twice, and here's your titles. Same thing as before, and then there's your instruction page. And there's your classification, and this is going to help your stats with the IRS. And this is what I was told, this is what helps make the IRS become your debt collector. Because you're letting them know that, hey, there's somebody in charge of this estate, and we'll be reporting to you, we'll be tax reporters for any undue or unpaid tax owed to us. Okay.
Okay, on mine, I turned 18 in September of 1987. So you wrote the entity making this election in accordance with Title 26, Section 2032A on the.
All right, now you're reading mine, right?
Yeah.
All right.
On the 3rd of March in the year of our Lord, 1988. So you went about 6 months to the date of my bonds, like when I.
All right, see that makes sense then. All right, so it's Sean, do you know why it's 6 months after, or why I did that, or why Brian did that?
It's I don't know. 90 days would make it a security, but I mean, I'm not sure what 6 months would do. I don't know.
Yeah, that's weird. I'll have to ask him. So just for now, we'll make a note. I'll ask him tomorrow, and then I'll post it in the group, and then everybody will get an email for what to put, and then I'll pull mine up. I don't know why I have it at 6. It doesn't make sense to me. Maybe I did something wrong.
Well, the date that you had that you were here and we filled out all of my paperwork was March. So maybe you were just matching it to the bonds and stuff.
Maybe.
Right.
No, that's when I did my bonds, was March.
Oh, okay.
Last year, or 2000. No, I was November. Never mind. All right. Not a big deal.
All right.
I'll find out tomorrow. We'll make a note of it, and I'll send an email out of what the first line should say. That's all. All right. So, I'll go over. I'll introduce court real quick, and then next class, I'm gonna show you guys my whole pack. I'll have it all scanned in so you guys can reference it, and then put your pack together. And then me and Laura will put a list together of what has to go to the Treasury, and everybody else. We'll put that together for you, It's be like a little checklist of what goes where, to who. And then you'll see how I mail stuff. You'll see all my thumbprints, how my friends sign it, how I sign their stuff. So you don't have to guess. All right, going to, where do I want to start? Did you ever post for kings and priests only in the group?
No.
All right, pull that up. Go to secure creditor 1. Yeah. Stop the pirates.
1 or 2.
1. Various. For kings. For kings. Change that view for Man X over there.
Thank you.
Put a view.
Certainly, right away. 1 second.
Awesome. All right, so this is, when you hear me talking about the state commissioner and stuff, this is probably one of the best reads. I've probably read it 10 times. All right, go down a little bit. I'm going to get into the juicy stuff real quick, because it's going to go over like the maxims of commercial law and compare it to the Bible. Go down 3 or 4 pages. This gets into the affidavit, and I'll see. Go down a little bit. All right. Up, slime. Keep going up. Keep going up. All right. Keep going up. All right, right there. Number 10. A lien or claim can be satisfied only through rebuttable by affidavit, point by point, resolution by jury, or a payment. Commercial law is non-judicial. This is prejudicial, not prejudice. This is timeless. This is the base, the foundation beneath which any government or any of the court systems could possibly exist or function. That means what the courts are doing and what all governments are ultimately adjudicating and making rules about are these basic rules of commercial law. When you go into court and place your hand on the Bible, you say, I swear the truth, the whole truth, nothing but the truth. You have just sworn a commercial affidavit. It's the conflict between commercial affidavits of truth that gives the court something to talk about. That forms the entire basis of its action and its being there, in their venue. Hence, one of the reasons attorneys always create controversy. Because if they're not agreeing, then you're arguing. And if you're arguing, you're belligerent and you're not accepting the charges. You're not manning up. You're not accepting it. You're not accepting the charge. You're not accepting the Christ. The acceptance comes in UCC Article 3-419. That's where the rule of your acceptance. That's contract law. No court and no judge can overturn or disregard or abrogate somebody's affidavit of truth. The only one who has any capacity or right or responsibility or knowledge to rebut your affidavit of truth is the one who is adversely affected by it. It's his job, his right, his responsibility to speak for himself. It's his job, his right, his responsibility to speak for himself, to issue his own affidavit, because no one can speak it for him. So this is when you hire lawyers and attorneys, you're just considered a child of the ward. You're a child, you can't speak for yourself. No one else can know what your truth is or has the free will responsibility to state it. This is your job. This phrase designates the whole body of substantive jurisprudence, example, the Uniform Commercial Code, the Truth in Lending Act, applicable to the rights, intercourse of persons engaged in commerce, trade, or mercantile pursuits. Black 6. Commercial law maintains the commercial harmony, integrity, and continuity of society. It's also stated as to maintain the peace and dignity of the state. Over the millennia, these principles have been discovered through experience and distilled and codified into those 10 fundamental maximums listed above. There is no legal issue or dispute possible, which is not a function of one or more of these principles. The entirety of world commerce now functions in accordance with the Uniform Commercial Code, the United States Corporation version of commercial law. And here you go. Collection and how to calculate your damages. Now, here is another aspect of your affidavits. In commerce, there is an assessment aspect. All right, so let me stop right here. This is where they're talking about an assessment. Ready? Now, lower this, minimize it, and come right back to it. And show them a little sauce. We're going to stay in the same folder and look up accountable. Accountable. Woo! When you're presented with an offer, it's not yet a true bill in commerce, or that is to say a firm offer. And you must first comprehend the true nature of a firm offer. So in the Bible, we're going to talk about a firmament, firm offer. This is anyways. And firm being the law firm representing the corporation making the offer. These corporations and representatives are unregistered foreign agents. So them being unregistered foreign agents, they cannot make anything but erroneous presentments and what would be theory liens without first going through the proper channels in order for it to be considered a firm offer. Or that is to say a true bill in commerce. Being unregistered foreign agents, they must have someone to vouch for them. Quote, Secretary of the State. A firm offer be a signed affidavit, notarized and apostilled in order to be a true bill in commerce. Then and only then can it be accepted or accepted for value and returned for settlement. Anything else is an erroneous presentment. If and when you receive an erroneous presentment, it needs to be returned by a notary with instructions for proper service. If you accept and return anything else, you are accepting the fact that it's not a legitimate offer and their status as unregistered agents and acquiescing to their assailment against you. As it is, they are obstructing commerce and commencing an act of war against you. Piracy, pirates. That's why the judge is a privateer. They're flying to Jolly Roger because you're a vessel. Their cops bring you to the dry dock. We'll post it all in the group. You guys can have all this stuff.
Is this where you would send back the presentment with the A4V wording over the top of it, stamp
Yes.
it, and then send it back?
With instructions, accounting instructions. You'll see right here.
Yeah, I don't have the account. Oh, the accounting instructions are in here?
If you accept and return it, you're accepting the fact that it's not legitimate. Hold on. Privacy. And you must conduct yourself as such and give them the opportunity to correct their actions. So what they're talking about is the notary presentment. This is your private administrative procedure. Your notary is your counsel or mediator with the foreign adversary. And you should not communicate with the adversary directly in any way. If the adversary corrects their action by sending the signed affidavit, notarized and apostilled to the notary, you can then and only then accept it for value and return it for settlement as a true bill in commerce. If they do not, then it is war. Time to take action and take some assets. All right, go down. When they send you a bill, ticket, charge, IRS, whatever they're sending you, the margin call, statement equals accusation. So you're being accused when you get a statement. They're the accuser, which is their responsibility to satisfy. They are overextended in derivatives. They have nothing. It is identity theft, counterfeiting securities, and insider trading. We are not their clerical administrators. That is why they are called public servants, public trustees. If you ask for the original assessment and the certified audit trail of all transactions for the original voucher expressly allowing for the back end copy, IMAD, OMAD, disposition and the disbursement documents, receipts, 1099 OID, 1099 interest, bid bond, performance bond, and payment bond. So it gets into GSA forms. This is where you need your cage code. You need a cage code to do these bonds. If you don't have a cage code, then you can get in trouble for filling this crap out, I guess.
I'm glad you said that because I was filling out all 3 of those bonds myself to try to go in and settle this case with the DA.
Nah. DA, I mean, you'll see. You can go talk to your county comp controller. They'll have this stuff. You can go to risk management with SIN Form 100. There's a couple things. I'll tell you. Everyone should have a copy of the bid bond, the performance bond, the payment bond, and put out by GSA, which is General Service Administration. The GSA is under the Comp Controller of Currency, which is under General Accounting Office. It says right there, General Accounting Office. Okay, you have 2 sets of bonds. This is your district court now. This is your standard form 274, 275, and 275A. At the federal level, say 273, 274, 275. Also be sure to ask for the signed certified verification of assessment and name of the registered public accounting firm and name of the auditor who assessed the charges. Credentials, oath, name, and contact information. Holla at me. Go down. All right, and this is where go to list of sureties. Why would they have a list of sureties in federal district court? When you click on this, boom, boom, tries to bring to the site. It takes you to this Department of the Treasury. Then you will see from Walter Burian, who has researched and spoken about CAFR, Combined Annual Financial Report of Cities and Counties, the hidden set of books, optional bids. It's all spelled out. The insurance companies are the weak link. They have the true liability. They also, by the SEC and fiduciary law, must disclose in their annual financial report any lien, encumbrance, claim, or judgment, giving the dollar amount liability, and short description, clear and comprehensive of the liability. Sarbanes-Oxley Act. They also are holding trillions of dollars of real investment assets, real estate and property, of which are subject to patent attachment by claim. They truly are the weakest link. So what they're talking about is the insurance now. Go down. Believe it or not, George Bush signed into law the act. It is amended. It's an amendment to the 1934 Securities Exchange Act. Old boy gave you an out. Think about that one. Dude's tearing down towers, but he gave you an out. That's why they took the towers down. Anyways.
Maybe he did feel guilty.
Yeah, go read it. It's actually a good read. I read part of it. It's interesting. 107th Congress, second session, 1934, on July 30, 2002, President Bush signed into law the Act of 2002, which he characterized as the most far-reaching reforms of American business practices since the time of Franklin Delano Roosevelt. The Act mandated a number of reforms to enhance corporate responsibility, enhance financial disclosures, and combat corporate and accounting fraud, and created the Public Company Accounting Oversight Board, also known as the PCAOB, to oversee the activities of auditing profession. The full text of the act is available here, link. The SEC does not control or maintain the site. You can find all links to all commission rulemaking and reports issued under the act at Here's their phone number. Go down. Enforcement, Section 105 of the Act 2002 grants the broad investigative and disciplinary authority over registered public accounting firms and persons associated with such firms. To implement the authority, Section 105A directs the board to establish, by rule, fair procedures for the investigation and discipline of registered public accounting firms and associated persons of such firms. As directed by the Act, the Board adopted rules relating to investigations and educations on September 29th, 2003. The Securities and Exchange Commission approved rules on May 14th, 2004. Under the adopted rules, the board, its staff may conduct investigations concerning any acts or practices or omissions to act by registered public accounting firms and persons associated with firms, or both that may violate the act. The rules of the board, the provisions of the security laws relating to the preparation and issuance of the audit report, and obligations and liabilities of the accountants with respect thereto, including the rules of the commission issued under the act, or professional standards. The board's rules require registered public accounting firms and their associated persons to cooperate with the board of investigations, including producing documents and providing testimony. The rules also permit the board to seek information from other persons, including clients of registered firms. All right, go down a little bit. Go slow. Okay. All right, go down a little bit. Provide office. Keep going. Okay. Go up a little bit. Okay. All right. Put together your discovery disclosure, demand for a bill of particulars, letter of undertaking, for whatever it might be, whoever the pirate minion may be as elaborate as you may see necessary with the discovery. Do not forget your negative averment. Once one has seen nothing that resembles anything that would establish a verified valid claim, nor has one seen any evidence of pre-existing contract. This would be application of your mother filled out for your birth certificate and is viable as it arises from presumption also. Or any additional information in the public record that would indicate any obligation or liability one may have regarding this matter. Heads up, Lewis, when you get your doc notarized, use a foreign consulate notary. Makes it international. Get a copy of the logbook for the evidence file. Have your doc sent by notary seal. Now, this is a very important point to understand. When you are looking for a claim on which relief can be granted, that is to say, where is it written in stone? When a law is passed through legislation, it is not valid until it is verified by the archivist in the Federal Register, logged. The notary is the archivist. I'm blotching that. Archivist. How do I say that? I'm saying it wrong. Is it archivist?
Archivist.
Archivist. All right, cool. And this is where he gets the power to supersede the court and the judge. When his log is entered into evidence, how many times have you had something notarized and did not get it? Not get the most important piece of paper for your process to succeed. The copy of the notary's log. This is the most important piece of paper for your process to succeed. This is your verified witness, replacing the presumption with fact. This is the why, as the Merovingian so eloquently states in the Matrix. This is what gives it power, a claim upon which relief can be granted. All right, skip that. All right. One rescinds any of all prior endorsements, declines any and all offers to a contract, and reserves the right to reject any and all bids, and does not concede to any presumptions. One is not the beneficiary of any compelled benefits arising out of the contract or agreement with the United States, USA, State of Washington, etc. Errors and omissions. One is not accountable for the errors and omissions of the offerer and offerer's partner, known as unknown. One is lacking the essential basic elements to formulate a valid assessment. For such a disadvantage based upon the truth, a presumption arising from duplicity must be viewed as voidable for lack of essential basic elements. Go down. Go down. If you want to use their own exploitation methods against them and put them in total ruin for those with vengeance in their hearts and minds, here you go. Here's the crucifixion. Send out your notarized discovery response timely under notary seal, certified and insured for over 50 notes. That creates a record in the Swiss-owned postal service, U.S. Post Office. Now set up a website, post all documents and evidence. This is where you can make a public notice to your county clerk, Secretary of State on the UCC. Mailing receipts to the site, main page on a link. Okay. Now get a newspaper ad, let's say maybe the New York Times, as private notice to whomever the little parasites are whom are causing the heartache. Any who presents may come and be seen known. Example. And here's the notice. So go down. You could post in the local city wherever there's corporate headquarters, and also mention their name, CEO, post a copy of your newspaper, add on the website, receipts, anything else pertinent. The bigger the newspaper ad, the more expensive. It just needs to be simple and pointed. All right, go down. All right, hold on. Never mind. No, don't move. Also, you can send a copy of the newspaper ad to the right from their website, the FASB's Technical Inquiry Service, the FASB Financial Accounting Services. Missions is establish and improve standard of financial accounting and reporting for the guidance and education of the public, including companies that issue accounting and reporting for the issue financial statements. They're auditors and readers of those financial statements. In line with that mission, the FASB staff provides a technical inquiry service to answer questions about existing FASB literature. We welcome hearing from you because your question may help us identify ways we can make our accounting standards easier to use and understand. The mission of the Financial Accounting Standard Board is to establish and improve standards of financial accounting and reporting for the guidance and education of the public, including issuers, auditors, and users of financial information. Counterclaim. If you have two claims that arise from the same transaction under Rule 13. So say if you get pulled over by a cop, here's their offer, now you have a counterclaim from that offer. That's mandatory. Federal Rules of Civil Procedure, Rule 13, you have to do a counterclaim. Oh, it says it right there. You have to do a mandatory counterclaim. If you do not do a mandatory counterclaim, which is a set-off or recoupment, you lose it because you waived it. So you're not getting your set-offs and recoupments because you have no counterclaim. Now they're going to address their claim that you have already made a general appearance, thus giving them venue and jurisdiction. And they are going to impose liability on you. Where is their lien? Where is their bond? Recoupment. Duhal's versus Truman. Duhal's tried to take a barge down the canal, which was not deep enough and wound up in a sandbar. Then he tried to do a quiet title under the abandoned property. The judge said that he had to post a bond if he wanted to pursue the matter. Escrow account. The bond replaces you. You have to be a lien holder or a claimant. How do you become a lien holder? Security agreement in UCC 1. That makes you the lien holder and entitlement holder, and now you can go in claims because you have the highest security interest. Lien holder or claimant to bring a claim in admiralty. See the Catrona case. You can do it by judgment or execution. Corpus juris secundum. In the footnotes, it states that the recognizance bond used by all of the courts comes from the Old English Admiralty. Stipulations and bonds, sections 156 to 160. 2003 revisions deleted this information. A letter of undertaking or stipulation is the same thing as a bond. What you are doing is bringing a chosen action against yourself as the res in an in rem proceeding in admiralty. Now, if you want me to explain that, I'm going to have to pull up another thing, and it's one of Gene's reads. Keep going, though. Don't do it. I'll get to it. Now,
Can we learn this stuff from Gene's class?
You can learn everything from Gene.
Okay.
Now, not if, but when they default, immediately file a countersuit in federal court. File your material in an evidence file, not the case file. One has heard something about a miscellaneous file. That has some further impact. That's what I always open up, a miscellaneous file. I never opened up an evidence file. I always opened up a miscellaneous file in district court. Anyways. That has some further impact. There must be further research, and one has real knowledge of it. Well, I have real knowledge of it. Subject, public policy court versus constitutional court. Reason why you can't enforce the Constitution is because you're not you didn't sign it. So like I said last class, you go to your county, you get the state constitution, get a copy of it, sign it, then authenticate it like you did your birth certificates. And now you're a signatory to the state constitution. Now you can enforce it in court. And now the judges that took the oath to uphold that, you can enforce it because, well, hey, homie, I signed it. Your oath is to uphold it. And that's how you accept their oath for value. All right, go down. Public policy, Senate, Constitution. All right, keep going down. All right. When you get into court and you are addressed, recite the disclaimer written above and tell the judge, I'm just here to collect. Then say in response to any statements they make, what relevance does it have at this time on this matter, Your Honor? When they're in default, is the court prepared to make a determination on this matter at this time? In your best Urkel voice. This is your pat cliche for anything they might have to say in regards to the matter. LOL. They have just been burned to the ground, commercially dead, crucified. They cannot win. Like one said, they've got nothing. If the judge dishonors this request, it may be because he is testing you and will press the matter, which he is entitled to do twice. But on the third time, it is 3 strikes and you're out. In such case, you can ask, are you sure? The first wrong may be regarded as an inadvertence. The second wrong constitutes intent. The third wrong signifies malice. Consequently, you may have to press your issue 3 times. Okay, go down. Now this goes into the Freedom of Information Act request investigation counterclaim for forfeiture bond. Goes into this. I'll get into all this stuff. This goes into why the request is made. US 5 USC section 50, to promote transparency and to ascertain the civil commission enabling the below named agents as members of the government. You're going down. Number 1, the bonding information and registration statement and name of the transfer agent, QSIP number and assessment, OMID, OMED, 1099 OID, 1099 interest for any and all charges. In regards to your name, and there's your case numbers, credit item number, if there's a credit card, municipal court, and authentication of authority. Oath of office and bonding information of credit items, signatory, Millard, city attorney, complainant, his ID number, and then ask for the bonds, go to account controller currency, go down. Then it gets in the 28E agreements between the state and federal governments to secure grants from the Fed and to ensure compliance with federal law by the state, and the yearly compliance statement to the Fed, showing among others that the state is in compliance with federal law and exactly where and how one is party to these agreements. Keep going down. It's a longer read than I thought it was. Keep going down. I'm trying to find the UCC1 stuff. Go down. Down, down, down. That's everything? All right, that was for accountable, right? That's what we just read, accountable? All right, good. Get out. That's good. Back to kings and priests. That was my read. But what that just said basically it showed you how to get the proper assessment, who to contact. I'll go over more of it. I'll put a letter of undertaking together for you guys so you can see it. All right, go up. Okay. No, you're good. Go down. Go down. Go down. Go down. All right, this is where I was. Assessment. Okay. Go up. Good job. My bad. All right. The collection aspect is based on international commerce that has existed. So when I tell you this is as old as Babylon, this shit is as old as Babylon, my G. The collection aspect is based in international commerce that has existed for more than 6,000 years. Again, this is based on Jewish law and the Jewish grace period, which is in units of 3. 3 days, 3 weeks, 3 months. This is why you get 90-day letters from the IRS. Commercial processes are non-judicial. They are summary processes, short, concise, without a jury. Go down. Well, where are you going? Don't go down. All right. The IRS creates the most activity of commercial collection in the entire world. The collection process is relatively valid. Although the IRS is not registered to do business in any state, did you understand what you just read? The IRS is not registered to do business or perform commercial matters in any state. So how do they get all the money they get? Answer, because you give it to them without requesting a proof of claim, 4490. Or even if they were licensed to give you offers based on arbitrary estimations. However, this is where things get very interesting. The other phase of matters is the assessment phase. There is no valid assessment. The IRS has and never can and never will and never could ever issue a valid assessment, lien, or levy. It's not possible. First of all, in order for them to do that, there would have to be paperwork, a true bill of commerce. There has to be sworn affidavits by someone that is a true, correct, and complete, and not meant to deceive, which in commerce is essentially the truth, the whole truth, and nothing but the truth when you get into court. Now, nobody in the IRS is going to take commercial liability for exposing themselves to a lie, and have a chance for people to come back at them with a true bill in commerce, a true accounting. This means that they would have to set forth the contract, the foundational instrument with your signature on it, in which you are in default, and a list of all the wonderful goods and services that they have done for you, which you owe them for, or a statement of all the damages that you have caused them for which you owe them. To my knowledge, no one has ever received goods or services from the IRS which they owe money. I personally don't know of anyone that has damaged anybody in the IRS that gives them the right to come after us and say that you owe us money because you damaged me. The assessment phase in the IRS is non-existent. It is a complete fraud. Wait a minute. There is one definition of service that actually applies to the IRS. Service. The act of bringing a female animal to a male animal to get so that the owner of the animals may enjoy the product of this union. This is why these rules of commercial law come to our rescue. T.S. Eliot wrote a wonderful little phrase in one of his poems. We shall not cease from exploration, and the result of our exploring will be to arrive at the place at which we began and know it for the first time. This is the beginning and this is the end. This closes the circle on the process. One reason why the super rich bankers and the super rich people in the world have been able to literally steal the world and subjugate it and plunder it and bankrupt it and make cattle property out of most of us is because they know and use the rules of commercial law, and we don't. All this. Everything's a master-slave relationship, and then the rest of it is just all within your temples. It's all in your head, everything else, just in your head. Those enemies that you create is your ego creating an outward projection of an enemy from within. There's no enemies. It's all in your head. Because we don't know the rules, nor use them, We don't know what the game is. We don't know what to do. We don't know how to invoke our rights, remedies, and recourses. We get lost in doing everything under the sun except the one and only thing that is the solution. No one is going to explain to you what and how all this is happening to you. That is never going to happen. These powers that be have no divulged rules of the game. They can and do get away with complete fraud and steal everything because no one knows what to do about it. Here's your solution. Well, what can you do about it? You need to issue a commercial affidavit. You don't have to title it that, but that's what it is. You can assert in your affidavit, I've never presented with any sworn affidavits that would provide validity to your assessment. It is my best and considered judgment that no such paperwork or affidavit exists. At the end of this document, you put demands on them. They must be implicit. And then you state, should you consider my position in error? You know what they have to do now, don't you? They must come back with an affidavit which rebuts your affidavit point for point, which means they have to provide the paperwork with real assessment, the true bill in commerce, the real sworn affidavits that would make their assessment or claims against you valid. Go down. No agent or attorney or fictitious entity can sign an affidavit for the corporation. How can they swear as a fact that the corporation has done or not done anything? They do not have the standing. They cannot and never will provide you with this. This means your affidavit stands as truth in commerce. You can even make it more interesting if you like. You go to all their laws like Title 18 and you tabulate the whole list of crimes they have committed against you in lying to you, foreclosing and selling your home and issuing liens and levies. This could be quite an impressive list. If you tabulate the dollar amounts of the fines involved in these offenses, you could take just Title 18, Section 241 alone, which is a $10,000 fine for any public official for each offense. That means for every single violation of the Constitution or commercial law, there could be 35 to 40 of these just in Title 18. You're looking at 300 to 400,000. When they start adding up, they become very impressive. Now you attach this accounting, the criminal accounting, to your affidavit, and you file it as a criminal complaint with the state attorney. This is like putting the fox in charge of guarding the hen house. However, more about this will be outlined. All right, go down. See, for now, just attach your affidavit and your criminal complaint to a commercial lien. But wait, there is a more effective way of getting your equity back: involuntary bankruptcy. These procedures are the reason you go through the criminal complaint is because by their own laws and value system and penalties, they have hung themselves. They have already discerned and formulated the dollar amount involved in each various offense. When you lien them for the amounts, they can't come back and say, well, these are out of nowhere. These are unreasonable. Where did you get this? Well, we got it right out of your own codes, homie. Commercial processes are non-judicial, prejudicial, and are more powerful than judicial processes. Now you take your commercial lien to the Secretary of State to file a UCC-1 financing statement. Then, as soon as you finish filing your original criminal complaint with the prosecuting attorney, you file this lien against every agent individually. The criminal complaint is optional. They can't hide behind the skirts of the corporate state, the fictional entity created by man, to be able to engage in perfidious actions, which you would not otherwise be able by virtue of natural and moral law. It just doesn't work. Go down. Now you can use the same collection process against them as the IRS uses against you. You will discover that all attorneys, judges, and people who come against you and think this is a lot of gobbledygook, hogwash, and silly, but they soon learn that your affidavit of truth is valid and enforceable against them. And they find that things become more and more uncomfortable with each passing day. Judges even think all this doesn't matter because they can get another judge to remove all your paperwork against them. Other agents of the government think they can hide behind the sovereign immunity of the government, behind all power and prestige, all their attorneys and all their capacity to get out of the courts to do whatever they wish is going to save them. None of these have any effect on your process. All right, go down. I think that's enough for this read. Let everybody else finish. Go down a little bit. I want to see. All right. It has no effect because there's only one way that can be saved, and this is to come in with their own affidavit that rebuts your affidavit point by point and prove you wrong. If you did get this into court or jury, that's not going to do them any good because the same battle still exists. All this means is that the conflict between affidavits are now fought out in the open court. And that is embarrassing to them because they're not going to change anything. This will simply do them no more harm. The third way to settle your claim is for them to pay it. If they don't satisfy your claim, give them a grace period. At the end of the 90 days, you transform the Secretary of State into your accounts receivable office. Legal title of all their real and personal property has now passed to you. You now file the correct paperwork with the Secretary of State, and you serve this on the sheriff and say, I want to take possession of my property, and that's how you start taking houses from public officials. If you send a criminal complaint on a public official to the insurance commissioner of the state, it becomes instantly and automatically a lien against the bond of the official, the judge, or district attorney, and he's dead. You cannot function without bonding. This is held in suspension until the issue is resolved. All right, that's all I wanted to read. All right, go get out of that. I'll go over Gene's stuff. No. Yeah, I got time. Stay in this folder, go down, go to Our Man's Day in Court. This is something I read off in court. All right, go down.
Would we be able to do this process in less than 90 days?
No. You have to. The default process takes 90 days because of all the grace. That's the proper default. You got to go by the rules.
Shit.
So I'll post this. I'm not going to read it. I read this off in court. I'll read it. Judge Lyman, case of John Henry Smith. Homeboy walks up. He shows he's a big dude, blah, blah, blah. Keeps asking the guy, are you the estate name, blah, blah, blah. Our man just ignores big boy because he's trying to, the judge is trying to act like he's in control. Because once they start telling you what to do, then they become the administrator. That's what they're explaining here. All right, is this being recorded? Yes, are you, blah, 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 blah. If I may read my statement, I think it will become clear. Okay, go ahead. All right, I'm John Henry of the Smith family. So this is where I would say I'm Polinsky, Peter Joseph. I'm here today to settle this matter regarding case number. I'm here today appearing specially and not generally in accordance to Federal Rule Civil Procedure Rule 8E to abate this matter of a worthless security interest known as a UCC1 commercial lien in the form of a traffic infraction against a Federal Reserve account in the name of John Henry Smith. A decedent said worthless security interest was created by an employee of the city of Tombwater who identified himself as John Weeks, badge number, date, a mere pirate operating under color of law, who on said date and with subterfuge attempted to attach private copyrighted dead man statues to me, a living man, for the express purpose of stealing my sweat equity. I then exercised my right of avoidance to this offered commercial venture by returning this abandoned and defective paper for cause without dishonor to Cheryl Wyatt of her agent, October, blah, blah. This was clearly a case of mistaken identity, as the charged entity is a decedent under Title 26 and not me. This is the basis upon which I move for abatement. Sir, you are prepared to abate this matter now? Judge Lyman, no, our man. I will continue my statement as follows. Let the record reflect that J.V. Lyman has denied the principal's motion for abatement. My rejection of the offer made by the city of Tombwater to raid the decedent's estate on John Henry Smith estate should have ended the matter. However, apparently this private commercial trading company Apparently, this private commercial trading company known as City of Tombwater Municipal Court, and then it has their DUNS number, their SIC, their cage code because they're dealing in securities. A storefront masquerading as an office in the judicial branch of the government and operating under the Department of Defense is hell-bent for its own personal gain on probating the estate of John Henry Smith, of which I am owner and principal. For the record, I object to the probating and said estate. Do not give my permission thereto. I'm here today for the express purpose of establishing my right of avoidance if anyone should attempt to impose a claim of distress against the person of my collateral. Any outcome on this matter other than an outright abatement or a check written to me for certified funds today, assuming the transfer of funds have already been taking place, will result in a demand to the DTCC, Depository Trust and Clearing Corporation. Go down. For investigation of fraud on the traffic infraction of fraudulent security. I now ask the following. Does the prosecutor have a 1099 OID in regard to the charge? There is no prosecutor here. Does the clerk? Because she's the one that put all this shit together. Judge Lyman doesn't answer. Just states our man. I've got my claim here. Where's yours? All right. And again, the Judge Lyman, he doesn't answer. He just stares at our man. And homeboy's holding up 706, 709, and 1099 OID. Tell me, sir, who is the payor and also who's the recipient of the fund is? Well, sir, if you're the recipient, then I guess you'll be paying the transfer taxes on this charitable contribution from the decedent's estate, which you're attempting to probate here. We both know that if you haven't paid the tax, you have no claim in equity. Are you ready now, sir, to abate this matter? Judge Lyman, do you have any evidence that the defendant is deceased? Our man doesn't even seem to notice the judge's question and continues on. Sir, have you paid the taxes? Do you have any evidence that the defendant is deceased? Sir, you have already probated this estate behind my back, huh? Under Title 26 U.S.C. 2002, you are personally liable for payment as the executor defined under Title 26 U.S.C. 2203 because you have actual and constructive possession of the property. It sounds like you would like this matter mitigated. I'm going to read the officer's affidavit in the record. The judge proceeds about a 5-page affidavit from the officer, and the officer covered just about everything possible except counting the dents and scratches on our man's car. Judge Lyman, I can determine from the officer's affidavit whether you committed an infraction of law or not. I am dismissing this matter. Our man doesn't even seem to notice the judge continues reading his script into the record. Sir, have you already taken a charitable contribution from my estate to fund your purchase of private equities and mutual funds? Sir, have you already submitted a 1099-R for that purpose? If you've acquired funds from the decedent's estate, that makes you a qualified heir, and not paying the taxes makes the property you stole contraband, which means all the forfeiture statutes kick in. And I've dismissed this case. Keep going down. Unless you abate the matter here and I'll give me a check for my funds you stole it, I'll be altering the Criminal Investigation Division of the IRS. I'll be alerting the Criminal Investigation Division of the IRS that you are guilty of tax evasion and money laundering, and to start an investigation on you personally with regards to my estate. Blah, blah, blah. I've read this off. I've won with it. This is when I was wet behind the ears. But you're not supposed to be going to these courts or speaking, and you all go into federal court. And everything is done through the mail. All right. I'll go over Gene's real quick, and then I got to get going. I got to be up early. I got to go see the county clerk tomorrow. All right. Type in Gene Keating overview. And this is what really put me above everybody with this one, this read, Gene's overview of Admiralty. It goes over everything. Goes into that res proceeding, in rem proceeding.
Hey, PJ, is there a time this week I can give with you on a 1040X?
Yeah, just call me.
Okay.
Yeah, that one, Laurel.
Is this doc in the group file?
This one?
Yeah.
Nah, I don't know. This might be. The other ones aren't. I'll have Laurel post them tonight. You want the accountable and for kings and priests only, and this one?
I got you gave me the kings and priests and the accused versus the accountable.
Okay. Okay.
So I'm reading that one now. But the one that you just read, just before this one here, was that the accountable versus the accused or a different one?
No, that's called Our Man's Day in Court. It's in the group. I'll repost it.
Okay, if she can, whatever docs you guys were talking about tonight, if she can just post those, then it'll be a lot easier to find them.
Okay.
All right, appreciate it, brother.
Mm-hmm. All right, so for court purposes or for court, this is the greatest read or the greatest, what can I call it? Not a treat, I don't know. It's just the greatest read ever. It goes over everything. You can't lose after you read this. All right, so it goes in the Admiralty Court has two different tribunals. Instant Court of Admiralty Jurisdiction of the U.S. Constitution, Article 3, Section 2, or the prize phase. Prize phase of Admiralty Jurisdiction is the War and Powers Act. This is why your U.S. citizens are considered to be enemies of the state. Article 1, Section 8, Clause 11, Law of Prize is a military venue, and when they do a capture, is done under the War Power Act, Article 1, Section 8, Clause. A seizure under the civilian venue is done under the U.S. Constitution. Right, so that's for your seizures. All is being orchestrated by the Lord High Admiral, the President of the U.S. That's why when they took all your gold, you had to go down with the ship. If the ship was sinking and you're a U.S. citizen, you had to go down with the ship. All your judges on the bench today are commissioned vice admirals under the King's Bench. The IRS Code 9.17 states that all assets or seizures are done under supplementary rules. A, B, C, D, F, G, under the Insurrection and Rebellion Act passed for the first of two acts was passed in 1861, and then the second was passed 7/17/1862. See Volume 12 of the U.S. Statutes at Large. Okay, so this is what happened. Emergency Bank Act was passed in, March 1933, aka War Powers Act, and Section 2 amended the Trading with the Enemy Act, originally passed on October 6, 1917, to include domestic transactions and made citizens of the U.S. enemies. Section 5B in the original act excludes domestic transactions and citizens of the U.S. Okay, so under Title 11, Section 109, all citizens are the U.S. are debtors in bankruptcy. And now Title 26, Section 6305, upon certification from the Secretary, the Commissioner shall collect the obligations as though we're a tax. It means they are collecting insurance premium. Everything is insurance under contributions. Tribulations are contributions. Go down. Okay, waiver and consent. Ramsey versus Allegra. Supreme Court decision. This is why if you do not go into the court, they arrest you. Use coercion to bring you into court to make you make a general appearance, so they can get venue, not jurisdiction. Venue is territorial. Your zip code identifies your military venue under the guise of the IRS. They want you to come into the court and ID yourself, which gives them venue. Then they assess your obligation under the contract so formed. The presumption is that you are the debtor. August 25th, 1983, the Federal Register designated all of your military districts by zip code, which identifies the IRS district. Because they do not want you to know that you are in military districts, each has a provost marshal over each district. Then they put a provost marshal general under the Bureau of War of Washington, D.C. over the provost marshals. A person was held in state jail without charge. The provost marshal was called, and he told the jail people that if the person was not released, they would be arrested. You have rights and remedies. They get you to go in and waive your remedy. Title 46, 781, and 782, this is your Public Vessels Act. Catrona, 1924, this is important. District Court decision and Admiralty, they fictionalize the vessel. They make the vessel, your all-cat name, your straw man, a juristic person. Public Vessel Act, 1925, they fictionalized the vessels in 1920. They passed the Suits and Admiralty Act. This is how you sue your officials in the Suits and Admiralty Act, where the U.S. waived judicial and sovereign immunity and they consented to be sued in Admiralty. That is where your Article 3 court is. That is where your common law is, under the Admiralty. Every state case should be moved under Title 28, Section 1446. It's 1441 to 1447, but the rule that they're using is 1446. I've used 1441, subsection A. This is how you get your order in, move to district court, move to federal court as a federal question under the Constitution, give district court original jurisdiction. And this is where I say Title 28. But district court original of all Admiralty maritime claims. Rule 9A says you can do that. Rule 9A is your negative averment. Negative averment is, I'll give you my name, but I'll pull up a negative averment after this. Hold on. Title 28, Section 1333 gives a district original jurisdiction exclusive of the courts of the state. These courts do not have jurisdiction under Admiralty. Nature equals Admiralty jurisdiction, cause equals venue in maritime law. Defense. Privity and knowledge means that if you commit an overt act that contributes to a loss, you cannot collect on the claim. The government created the problem by overselling gold contracts. They want everybody to pay for their loss through contributions. Your Joint Tort Seizure Act. Every state has passed a Joint Tort Seizure Act. A tort seizure is any person who has committed an injury or a civil wrong. Every time they bring you into court, it's a maritime tort. All right, go down, down, down. Get past this. Go down, down. Okay, okay. Right there. Up. It's okay, right there. So Black's Fifth, Seventh, in rem, a technical term is used to designate proceedings or actions institutes against a thing in contradistinction to personal actions, which are said to be in personam. An action in rem is a proceeding that takes no cognizance of owner but determines right in specific property against all of the world, equally binding on everyone. It is true that in a strict sense, a proceeding in rem is only taken directly against property and has for its object the deposition of property without reference to the title of individual claimants. But in larger and more general senses, the terms are applied to actions between parties where the direct object is to reach and dispose of property owned by them or some interest therein. Such are cases commenced by attachment against the property of debtors or instituted to partition real estate, foreclosure of mortgage, or enforce a lien. In the strict sense of the term, proceeding in rem is one which is taken directly against property, or one is which brought to enforce a right in the thing itself. Actions in the court is required to have control of the thing object in which an education is made to object which bonds the whole world are not simply the interests of the parties to the proceedings. All right, go down. All right, res is everything that may form an object of rights, includes an object, subject matter, or status. In Riggle's will, the term particularly applied to an object in an action, or the object against which directly proceedings are taken. So when they're coming again, you're the res. Thus, in the prize case, the captured vessel, you, is the res, the all-cat thing. And then because you don't put a surety bond up or bring your insurance into court, your body becomes the insurance for the res. And proceedings in the character are said to be in rem. See personam in rem. Res may also denote the action or proceeding as when a cause, which is between the adversary parties, are entitled in. All right, go down. Then it goes into the Emergency Bank Act, was codified in Title 315118, subsection 2, subsection D. It is hereby declared that to be against public policy for any contract obligation to contain clause which purports to give the obligee the right to demand payment in any kind of specific coin. So what that means is nobody can ask you for a specific coin to pay. Like they can't ask you for gold coin. They can't ask you for Federal Reserve notes. That's why when you get these bills, they send you the method of payment. They send you the money order. But if your accounts aren't set up right and you don't know what you're doing, and that the acceptances doesn't work, your set-offs don't work, anyways, under the UNCITL, United Nations Commissions on Trade of International Law, they superseded Article 3 of the UCC in December 5th of 1988 in New York City. It is no good anymore under this convention. They have an international UCC, and it tells you how to do these bills of exchange. There are 96 articles in this convention and tells you how to do international bills of exchange. Bank checks are international bills of exchange. The United Nations Treaty and Supreme is the supreme law of the land, not the Constitution. The United Nations Treaty is the supreme law of the land, not the Constitution. Okay. Then this talks about getting rid of your citizenship. Go down. Then IRS uses secret liens by operation of law, and this is where your maritime tort comes in. There's salvage claims, wage claim, and general averaging claims. The maritime tort will be Title 10, Section 51 through 61. That's the maritime tort. That's important. That's where I read from, and I pull. I have a book on torts too that I'm putting together right now. Special commission is required in prize proceedings, which is a letter of marque. And then if you watch Pirates of the Caribbean, they speak of the letter of marque. They put it out in movies. It's just funny to me now. I mean, but you gotta like they say, you gotta have the eyes to see and the ears to hear. Do you have a letter of marque undertake under the King's Bench with special commissions to collect revenue? The Bible is the law book. The common law is divine law. See Matthew 24, Daniel verse 12, 11 and 9. All right, read the Catrona case. You cannot come in, deny, or defend in an admiralty proceeding. So when you get creating an argument, or you're defending the estate, it's all wrong. That's why we do it in acceptance. We're accepting the charge. We agree with our adversary. That's in Matthew 24, verse 25, I think. Don't quote me on it, though. State courts do not have a commission. They are doing civilian seizure of the rate. The judge is trying to get you to come in and make a general appearance so he can get jurisdiction over this trust, so he can collect a claim under general averaging contribution, which is a maritime tort based on negligence. You are awarded the court under admiralty. Go read Garrett versus McCormick, 1943 decision. It is a SDK trust. He who has a right to a beneficial interest in and out of an estate, the legal title to which is vested in another. The person who possesses the equitable right to the property and receives the rents, issues, and profits thereof, the legal estate in which vested in a trustee, beneficiary of trust. You must do a financing statement and security agreement when you do a UCC-1 filing. You have a trust fund. They are after the trust fund. They are out to arrest the trust. In order for them to get in rem jurisdiction, they have to arrest the trust. They have to have a constructive custody or actual possession of the trust. There are only two ways that they can get that. They have to get it through the owner, so they have to have the owner come in and make a general appearance. That is why in rem proceedings, it is always involving title. You cannot come into an admiralty proceeding unless you have an interest in the vessel. Now, what's your interest? Security agreement. That's your security interest. Your lien is UCC-1. The only way that you can have an interest is that you have a statutory lien that is with a UCC1 finance, and a security agreement are a statutory lien. And that is what gives you the authority to sue under Rule 9A. Okay, and then he goes into counterclaim. If you have two claims that arise in the same transaction, Rule 13, you have to do a mandatory counterclaim. If you do not do a mandatory counterclaim, which is a set-off or recoupment, you lose it because you waived it. Now that you're going to address their claim, you have already made a general appearance, thus giving them venue jurisdiction, and they are going to impose liability on you. Where is their lien and where is their bond? Where's your affidavit? Where's your surety bonds? I have all that stuff in my writ quo, pro quo warranto, recoupment, Duholz versus Truman. Duholz tried, all right, we read that one. All right, read this stuff. This was in Kings and Priests. All right, so you become an intervener in the accordance to federal. This is like being a claimant. Federal Rules of Civil Procedure Rule 24, you're intervening for the estate. See, in admiralty, you have a plaintiff and a defendant, but you have a plaintiff or a claimant, a defendant, and an intervener. You're trying to come in as an intervener because that is the only way you can win an admiralty without giving the court jurisdiction or venue. Once you give them venue, you're the debtor. You have subrogated yourself. The word subrogation means substitution. You have substituted yourself for the debtor/defendant under the bankruptcy laws, Title 11, Section 109, and the fourth section of the 14th Amendment, which says that no citizen or resident of the United States can challenge the validity of the public and national debt. You use international bills of exchange instead of Federal Reserve notes. UN Commission on Trade, Law on International Law, December 5th, 1980. This superseded Article 3. Great Whore of Babylon, Project Wormwood. Look that up. All right, go down. Go down. Go down. This is just, I mean, this is how good reason I just feel like getting into all of it.
Is this whole document only 18 pages?
No, it's 18 pages. All right, you can do a letter undertaking or stipulation. Get it notarized and have got yourself a recognizance bond. We just read this. That is why you have to use procedure. The attorneys in Cactus Pipe and Supply Company went into the court and got nailed. Cactus was the supply company, and they sued one of the freighters that carried the pipe because they had an accident and damaged the goods. They sued the vessel, but they did not arrest the vessel. Because they did not arrest the vessel, they did not have any in rem jurisdiction. So what did the attorney do? He made a general appearance and waived the requirement for arrest and for constructive custody of the vessel. So the court would have in rem jurisdiction. Then the court got in personam jurisdiction and imposed that on the attorney, which transfers the liability to him, all in one. And here's your Federal Removal Act, Title 28 U.S.C. 1446. And like I said before, 1441, 1447. I think I used 1441 subsection A on my last one. Benedict on Admiralty, Changing the Face of America, Volume 1, Section 23, page 137, states that the savings clause of the Judiciary Act of the Judicial Code, the federal district courts will have original jurisdiction of all claims in admiralty maritime law. Savings to the suitors and remedy in common law where common law is provided for. Therefore, you can take an admiralty maritime claim and adjudicate it in the state court, and the common law gives you remedy. The problem is that now, this was back in 1789, and you do not have any common law anymore. They have reversed everything. Now you have to go through admiralty to get to your common law. If you get out of the system, you can use the common law. You can do a Rep. Levin, get the common law pleadings by Joseph H. Koffler. I have pleadings in equity. That's a crazy good book to read. That shows you how to default them. Goes over the bill of complaint, a bill in equity. All right, so Truth in Admiralty Act, have to go in district court. That's where your Article 3, Section 2 bestowed original jurisdiction. Okay. Here's how they get jurisdiction over you. SS5 application, postal service, citizenship. Denying jurisdiction and staying out of jail. The res, which is the subject matter of the complaint, has to be within the territorial jurisdiction of the court before they can have in rem jurisdiction. That is why they have to arrest the vessel. Where do they get this territorial jurisdiction? Under the Insurrection and Rebellion Act. They have a provost marshal over territorial provost marshals. When you are served, return the papers to them. This is how they get venture. Appearance does not mean they're going to the court physically. The word appearance has been defined as the act of appearing and the act of presenting oneself in a state or form of one appears. The capacity in which you appear that determines whether it is general or special appearance. Now, you don't go because only spirits appear, right? When you've seen that crazy mountain man talking about all that, he was right. Only spirits appear. So if the state is dead and your estate is dead, and you live person comes, well, you just gave life to it, and now you're responsible for the charge. You're the insurance. And this is some things that Gene says. I'm here without prejudice and without waiving any rights, remedies, and defenses, statutory or procedural. What is your defense? Lack of jurisdiction. Federal Rules of Civil Procedure, Rule 12b2. No in rem jurisdiction. You have to waive it if you make an appearance. So what you have to do is make a special appearance. And you do that by stating on the record that you are here without prejudice, without waiving any rights or remedies. Note that you can invoke unalienable rights because you have none in admiralty. The Constitution does not apply in admiralty court. All right, that was good. And then real quick, go over admiralty law. You lost that C. I'll show them the bill of complaint. All right, just go down. I'm just gonna go. I'm not reading any of this stuff. Go down to the examples of the bill of the pleadings in admiralty. I'm just gonna go over like the first couple paragraphs. Right there. All right. So the first paragraph. See, they say pro se. I change that to sui juris appearance, especially under supplementary rules of Federal Rules of Civil Procedure, Rule E8, restricted appearance in the original and the alternative as a matter of a right and privilege, and enter their answers. Supplemental Rules of Federal Rules of Civil Procedure B3B to alleged rights under maritime liens and notice of intent to levy respondents, libelants, and libelant in the first instance, absent their verified oath and solemn affirmation of complaint pursuant to so this is where your complaint comes in. And here goes all over the titles, and this goes over what they've but in mine, this is where we add all the charges to. Keep going down. Number 2, this admiralty maritime cause of action within the meaning of Federal Rules of Procedure 9H pursuant to Title 28, Section 2461 and 2463. All property taken or detained under any revenue of law of the United States shall be deemed in custody of the law and subject only to the orders and decrees of the courts of the United States having jurisdiction thereof. Okay, the venue states district court is mandated district court of the United States having de jure venue to hear the cause of action, etc., pursuant to 5 Stat 516, Chapter 188, Section 5, enacted August 23rd, 1842. Pursuant to the Act of September 24th, 1789, Chapter 20 of the Constitution of the United States of America, Article 3, Section 2, and in that respondent, libelants et al. Are directed by the governor of the fund, aka Secretary of the Treasury, Raul Maldonado, alien custodian, for prize and booty, and are foreign agents of their principal to the fund and the bank et al. Fortiori mandates pursuant to the law of the United States, America, Title 22 U.S.C. Foreign Relations and Intercourse, international organizations, Chapter 12, 286G, jurisdiction and venue of actions. B, any such action at law to which either the fund or bank shall be party shall be deemed to arise under the laws of the United States, and the district courts of the United States shall have original jurisdiction of any action. So keep going down. You have notice of foreign law, notice of classified information, and there's 4 of them in here, but this is one way to come in the pleadings in equity, and this is a bill of complaint. And I'll have Laurel as your cause of action. And when we're claimants, petitioners, and here's your prayer for relief that no one ever talks about. All right. And then never pro se, always sui juris. And then that's it. That's a bill of complaint. But I can't go into depth with it because I'm not comfortable with my bill of complaint yet. But once I'm comfortable with mine and I've won 5, 10 foreclosures, I'm already on 5. Then I can go in depth with you and go over each section of the bill of complaint with you. But as you can see, your UCC-1 security agreement, an affidavit, and a bill of complaint in district court will get you what you want. And if you understand the private administrative procedure of defaulting, you get your dividend payouts. But you have to have your security agreement and UCC-1 filed, and especially a public notice at the county. So I'll just go over court real quick. Boom, officer, we'll just make a simple one. Officer pulls you over, automatic federal rules of civil procedure rule 13, automatic counterclaim, put your bill of complaint in federal district court, put an order into the municipal building, notice of removal, Title 28 USC section 1441, or up here, that's 1446. And then bring up your assessment, do the accountable, put your affidavit in with the insurance commissioner of the state, and default them. Make sure you have your notary, get a copy of the notary log, and then default them, then go do your private administrative procedure. All it is standing on your square and knowing who you are. There's a million ways to skin the cat, but you got to know their procedures and the default process. It's important. All the law, I'll repost my commercial notes. If you guys reverse engineer on my commercial notes and look everything up, then you'll grow into that and you'll be able to stand on your square. It goes over the accounting forms that they have to do. It goes over everything. So I think next class, I'll go over court with you. Sean could do the address change. Oh, no. I got to show you guys. We'll do UCC-1. I'll go over more court as well, and the address change. So we'll do the UCC-1s, an executive letter real quick that I created, and then that'll be that class. Default process is the 3-step private administrative procedure read, and it's in the book I'm reading now. It's called A Treatise on Equity Jurisprudence, and it goes over the default process. So then once you default them, then you take the default to the Secretary of State, get a certificate of default, put that on a UCC-1, and then you take that into your brokerage account, and you get your security broker, and then you get a dividend payout. And that's pretty much it for court. It's not that pretty much it. I'll go over it and I'll put out my templates and stuff and how I handle it. But federal court is where you get your discharges, your recoupments. That's where the law is upheld. You gotta stop fighting with them on the municipal and the state side. Bring it to federal. And the referees, I've always had a good standing with judges in federal court. There's more respect there.
Which document did you say I could learn how to do that?
Learn how to do what? Default?
No, take my. My court case is in 3 weeks, and it's in municipal, and I want to move it to district federal court.
Oh, Laura, can you pull up the notice of removal? I think you have it, a rough draft one or a template. Notice of removal.
Pito.
When you remove it, they typically give you like a later date to prepare for.
You're mumbling. I can't hear you.
When you move it out of court, when you move it from one court to another, do they typically give you enough time to prepare for that one?
There's nothing for you to prepare when you move it to federal court. You better have everything else ready.
Okay.
Yeah. No, damn. I thought it was in there too. I could have swore we had.
Sorry, man. Go ahead.
No, you're fine. Go ahead, Mark.
I don't know if you remember, but I had that credit card thing I was dealing with my wife. Well, we won it, but they're appealing to the state court now. But the attorney that brought the case, excuse me, was a no-show to the court. And some other attorney that represented Capital One decided to show up. He made the mistake of admitting in front of me and in front of the judge that he wasn't affiliated with the firm that brought the case. The judge let him off the hook, didn't make him, file anything. So there's nothing on the docket identifying this guy that appeared for this case.
So anything that he says, you object. Anything that he says, you object to, and you say,
well, that's Well, the firm that brought the original case, I won that case. I got the judgment in our favor for that case. But
Good.
now the firm that brought the original case is appealing to the state Supreme Court.
That's fine. Go to Supreme Court. You'll win. You'll probably be a benchmark case for the United States. Court is court.
Okay.
Court is court, no matter if it's municipal, federal, or it's all the same. Court is court.
I was just going to do an affidavit.
All right, Laurel. It's on my other computer. I'm sorry, Mark. Go ahead. You're doing the affidavit.
That's okay. That's all right. I was looking at doing an affidavit. The only problem is I've never done an affidavit in my life. So I have to sit down.
Don't overthink it. It's easy. Laurel, post up the template for the affidavit.
Well,
I'll have Laurel post a template for an affidavit. I use this one, and then whatever the case is, I add on to it.
Which one?
Okay.
Where it goes that I. The one you just did for Doc.
No. 1 second.
Go into Secure Creditor 1. Stop the Pirates or Redemption Manual 4 or 5. Go down to affidavit sample form. There you go.
All right. Yep. That's what I was thinking of. I figured it would be something simple.
Yeah, all this stuff. It's all man-made. You got to keep it simple for these guys. You know what I mean? Because believe it or not, the judges do know what's going on, but most of them are in the dark about this stuff. And then when we come in, we're a special case, and the feds come in. They really watch this stuff.
Yeah.
But you're fine. You're good. But this is what I use as a template. This is what I use to start off all my affidavits. Everything.
Cool.
Then here you could post. Laura, pull up my affidavit follow-up. You guys can use all this one. I just got word that feds and other private attorney generals and the federal, they're using my affidavit follow-up. Go down. So you guys can have all that ones for discharging.
Would you send the follow-up after you send the affidavit, basically telling them?
No, I put this in federal court for my discharges. This is my affidavit for discharging.
Discharging debt or just discharging anything?
Everything.
Okay. Now with the affidavit that you had earlier, would we be able to list, like, when you were going through that document before where you were talking about basically all the fraud that they've been involved in, if we listed point by point the different frauds that have put us in that court or in that case, and they don't rebut that, does that basically stand as truth and they can't come after you after that point?
Right.
And that's how you avoid actually going into the courtroom.
Right. So you file the affidavit. So what you're okay. So this is different from a criminal complaint.
Okay.
Okay. So this is for this one. We'll just keep simple. Just say, hey, we're discharging debt with this one. This isn't for like criminal court. This isn't assessing charges. What you want is an affidavit. You want to make a true bill, right? So you want to go over. I'll show you my affidavit next class. You'll see all the charges and how I did it. So anyways, this is for discharging. You can go down a little bit. And then you guys can reverse engineer this. They can't get past this. Nobody anywhere can get past any of this affidavit. I know that for a fact because people walking me through the rest of my procedure that said, well, we're using this one. I was laughing. It was cool. I put a lot of work into it. It goes over, it just goes over everything. Through the acceptances, codes of federal regulations, internal revenue manuals, United States codes, UCC, tax law. I have it all in here.
Jesus. Nice.
Yeah.
All right.
You can hear the
Well, if I could
screaming.
Would you please post that?
Yep. Laurel, we put that in the group.
Yeah, I've got a list of a whole bunch of stuff that'll come out tonight before I go to bed. I'll make sure everything's posted for you guys.
All right.
All right. That sounds great.
All right, guys. I'm tired. I love you guys. I'm not going to do questions tonight because I got to get to sleep. I got to get up real early. I'm sorry. But next class, we'll do the UCC one. You guys will see my entire trust. Sean's going to put his sauce on. I'll show you how to okay, so my buddy's giving me the template and the step-by-step for the Freedom of Information Act. I go down to New York Monday, so I'll have that Monday.
What? Yeah, when I'm done with this class.
All right, guys. Guys, everybody have a good night. Thank you for your participation. Thank you for showing up. Thank you for all the hard work you're doing. Stay persistent. Stay following your heart. I love you guys. Have a good night.
All right, man. Be good.
Good night, everyone.
Thanks, Pizza.
Thanks, Laura. You have a good night.
All right.
Thanks, Laura.
You're welcome.
Thank you, Laurel. Thank you, Sean.
Thank you so much.
Good night.